Now I want to bring into the frame Business Rescue Specialist Tokelo Moloi, who joins us on South Africa tonight. Thanks for coming in this evening. What is your view, at least one of the unions saying the process is lacking legitimacy?
Good evening to you, Jamie, and the viewers. Jamie, the law is very clear about business rescue. Voluntary business rescue, it's a decision taken by the board. And once that decision is taken, filed with the relevant office, which is the CIPC, that decision is valid. If any person does not support that view, the law is clear again in terms of the act that they can apply to court to set aside that decision. So as far as we stand currently, the resolution has not been challenged. The decision that has been taken is valid until set aside.
So while it might have been the politically correct thing to do, possibly to consult the unions, there's nothing in the law which says that the board had to consult the unions before appointing Mr. Mattison.
Read directly from the Act, the decision is that of the board. There is no requirement in the Act for a consultation.
So when the union turns round and says this is simply liquidation under the guise of business rescue, again, how do you respond to that? Is that more rhetoric on their behalf?
Look, a business rescue is intended, to turn around the business, alternatively to yield a better return than a liquidation. It's a creditor-driven process, which is in the interest of all creditors, including the employees. Now, unfortunately, the process has not commenced, so it's quite premature to make a determination that less will not be independent unless there's evidence that supports that.
But I need to be absolutely clear on this one. The process itself, as the board has constructed it, is legitimate. The business rescue practitioner can go ahead with what he's doing. He is duly mandated by law to do so.
Correct.
All right, now let's move on to the claim by both Solidarity and NUMSA saying that they'd like their own person involved. Would it be allowed, again, in terms of the law, to have more than one person involved in this? In other words, people protecting the various interests of, say, Solidarity or NUMSA?
Jamie, what we've seen currently is that the Act does not prohibit the appointment of additional business rescue practitioners. So we've seen some cases where, in terms of the Act, the business rescue practitioner who is appointing additional business rescue practitioners. So it is possible that through this engagement, Les may well agree to have another business rescue practitioner appointed. Alternatively, if the unions are not happy with his appointment, they may approach court to have his appointment set aside. And to do so, they would have to obviously highlight certain requirements in terms of the Act.
But he wouldn't necessarily do this to appease the unions. He might do this, for instance, because the job is simply too big.
Well, for him to take the appointment, he has to make that assessment. Every single business rescue practitioner that we've seen in the industry normally has his own team that he works with. However, if the work is too much and he believes that having someone else to join in is necessary, he will have to make that decision, because he's now taken over in terms of Section 140A from the board, and he has the authority, if he desires or if he agrees with the union, to appoint an additional business rescue practitioner.
While he's embarking on this process, how consultative, or to what degree does he have to be involved in a process, if at all, of consultation with various stakeholders? Does he need to be talking to the board? Does he need to be talking to staff and to the unions and other stakeholders?
Look, the Act is very clear in terms of how we go about business rescue. It does not prescribe how we should go about consultation, but it does require that within 5 business days of his appointment, there should be a meeting where he will make a determination whether there is a prospect of rescuing this business. Now, I'm not sure if he'll have enough time to consult all the stakeholders before then, but he would have a team that can assist him with that.
All right, so he's 2 days into it now. So in terms of the law, he's got another 3 days before he's got to start thinking about presenting a plan. So let's assume that he is not sitting on his veranda having a glass of wine tonight, but he's probably working very, very hard. Where would he be starting this process then in order to deliver that preliminary assessment?
Look, the first thing you'd have to do is to obviously engage management, engage the employees with his team to make an assessment. Having known most business rescue practitioners, they would have made an assessment prior to being approached, prior to accepting the appointment. So a lot of work should have been done by Les, so he should have a reasonable sense of what's happening in the business.
What I'm not understanding is what would constitute the assessment. So he's talking to the various parties about what? If you were sitting there, what questions would you be asking?
So the first thing that one would look at
You're probably very grateful that you're not.
Yeah, it's a big mandate.
It's a big job, yeah.
Look, at the moment, I think the biggest challenge that he has is to manage the stakeholders. In terms of the financial information, he will have a team dedicated at looking at that. In terms of the operations, he will have a team looking at that. But his focus at the moment is to manage the legal issues that may occur, which may delay the business rescue, which may then affect the prospects of success of this company being rescued.
What happens if people don't like the initial assessment? What recourse do they have?
If at the first meeting a decision is taken that he does not believe the company can be rescued, he will have no other choice but to approach court to apply for a liquidation. And those that don't agree will then have to bring an application to oppose the application for liquidation and seek that the company continue in rescue, and then seek a different business rescue practitioner to be appointed.
But if the unions wanted to interdict before that, they would find things very difficult.
Yes.
So in terms of where he's going now, he's got 5 days to deliver that plan. Then I understand a further 25 days, at which point he also has to deliver what?
So in the 5 days, he is not going to deliver a plan. He's going to give a preliminary view of whether or not he believes the company can be rescued.
So that's one sentence. I think it can, or I think it can't.
Yes. And after 25 days later, he has to publish a plan that set out how this company can be rescued. We've seen in practice that most companies ask for an extension because this is a big company. It requires a lot of work. A plan may take 6 months to be published, depending on the complexity or longer of the matter.
There's some research that says under 20% of companies who go into business rescue actually succeed. So what do you give the chances of this particular exercise from happening successfully?
Look, I don't like to speculate, but I'm confident that the business rescue practitioner has been appointed with the 35 years experience that he has behind him. He will definitely find a solution together with the stakeholders that can rescue this business.
But that's going to be his single biggest challenge, because it's patently obvious, given what we've heard today from NUMSA and from Solidarity, that the unions themselves could make business rescue difficult.
You know, I think one must also take into account that there are two objectives that must be achieved. One is to turn around SAA to continue as the same business. Alternatively, is to sell it to another entity who will then allow enough money to come into SAA to settle creditors than to go into liquidation. So there are a number of ways that a success can be achieved.
Something else is troubling me slightly, and maybe I've just misheard you, but you said before he was announced he would have been doing some preliminary work anyway. He would have an understanding of the scale of the problem. Am I correct? Did I hear you correctly? Yes. Which also says to me that this plan to go into business rescue was obviously being considered by the board weeks, maybe even months ago.
The experts in this area have always believed that every single business rescue practitioner must do what we call a pre-assessment. So when the board approaches you and informs you that they would like to nominate you for a business rescue, appointment, the first thing you have to do is to actually look at the information that they're presenting to you and make an assessment that do you really believe that this company can be rescued? And if you do, then you say, look, I'm prepared to consider the appointment.
So that's important, because he wouldn't have taken the job, is what you're saying to me, unless he believed it could be rescued. So there's some optimism here.
Yes.
All right, well, we'll see what happens. 5 days, then 25 days. And remember, we've got Christmas in between. Tokelo Moloi, thank you very much indeed for your insight.